Lovely to be here tonight. Thanks for giving up a nice sunny evening to be here. I'm sure you probably prefer to be outside having a barbecue or whatever, so I won't take up too much of your time. I'm Flora. I've spoken previously to you, so again, thank you for listening to me again. I'm at Lockton. Lockton are the insurance brokers who place the insurance for the Acupuncture Council, and I'm a 14-year qualified clinical negligence and medical regulatory defence lawyer. So I sit within Lockton and I head up our advocacy and risk management practice within the healthcare practice. So I've been asked to talk to you today about consent. It's a very thorny issue in medical malpractice generally. I'm obviously tailoring it to you as acupuncturists. You'll have to bear with it a little bit because some of it, for example, if we're talking about a spinal surgeon, not that I'm talking about spinal surgeons today, but just to give you an example, you know, spinal surgeons' consent is obviously going to be different to an acupuncturist consent, but many of the principles are the same. So some of it might look a little bit overkill, but it's really important that you take away the key messages here because they do apply to you just as much as they apply to the spinal surgeon, for example. So if I can have the next slide, please. I'm going to focus here on, I've put a quote about litigation as the ultimate lottery. A barrister spoke about it in those terms the other day, which of course doesn't sound hugely reassuring when you think about something as massive and all-consuming as litigation. That's the point, really. Litigation can be a lottery due to all sorts of elements, which can depend on, you know, the judge that you end up in front of in court, the quality of the experts, the quality of the lawyers, indeed. There are so many factors, you know, the performance of witnesses, so many factors in litigation, even though law in some ways can be seen as black and white, there are the grey elements, and all of that can just combine to mean that litigation's a lottery. And my role really is to make sure that you don't end up anywhere near that, and that you don't get into trouble. And consent can be a massive area which can cause trouble for practitioners. And then I just want to look at it from the angles of what you can do to protect your patients and yourselves. So to protect the patients and yourselves, that's two sides of the same coin, really. But the latter part about what you can do to protect yourself focuses a little bit more on record keeping, because for me, consent and record keeping are really inextricably linked. So we can have the next slide, please. So, you know, in terms of avoiding litigation, as I say, the main reason you want to avoid it is because it can be such a difficult thing to predict. You know, you will never get a barrister that will say to you, you have 100% chance of winning this case. You'll never get that. In all my years, the highest percentage I've ever been given of winning a trial, and we've had some very strong cases, has been 70%. They're rarely ever likely to want to give you more than that. But aside from that, why is it so important? Well, you know, being involved in litigation, and I don't just mean going to court, but actually just the beginnings of being involved in a complaint, it can be hugely stressful, and it can be damaging to your reputation depending on who is making the complaint and depending on whether they are trying to perhaps put their complaints and their feelings on social media. And then if it does develop to litigation, then the problem is the media can get involved, and it can be really damaging from a sort of public profile perspective. And why is it important too? Just the next slide, please. It's also to do with the time and the money. It's hugely time consuming and costly to be embroiled in litigation. And if the Acupuncture Council has to pay out on your behalf on a claim, then that will eventually affect the premium. It won't necessarily affect the premium if there's just one small payout a year. But if there are lots of payouts, that's then going to have an impact on the membership fee. So there's all of those areas which combine to mean that you really want to avoid getting into trouble in the first place. So if I can have the next slide, please. I've got a couple of examples. I've got 3 examples of cases which we've seen, which demonstrate how practitioners have ended up in trouble largely because the consenting process hasn't been quite as we would want it, or at least the consenting process not being as we would want it has made the cases more complicated, more difficult to defend. That's the main point here, because you can have, that's something I want to stress, you can have something that goes wrong. You can have something that goes wrong technically. Now, if you've warned a patient of that, and if that's all documented, it's a lot harder for them to then bring a claim. If you haven't warned them about the possibility of this going wrong, that is when the problems arise. Or alternatively, if you have not documented the fact that you've warned them of this risk, that can be where it's very, very difficult to defend. So one example we've got is a patient who is receiving treatment for shoulder pain, and they allegedly suffered a pneumothorax when they were being needled. Now, I say allegedly because there are possible other causes. The pneumothorax didn't manifest until a few days later. So other things that have been suggested could be the cause of sports that the individual was playing and smoking and so on. But the lack of a consent form in this matter is just making it much more difficult to defend. Now here, the risks were explained verbally prior to treatment, but the practitioner admitted there was no mention of pneumothorax and there was no written consent obtained. So that is one example of a pretty tricky matter that we've had. If I can have the next slide, please. We've got another one, which is another pneumothorax. So they can obviously be incredibly serious and incredibly costly. We haven't seen any for a while, and then we've had a couple, but this one, the patient was receiving fertility treatment and they suffered pneumothorax when being needled, and they'd admitted to hospital the next day. Now, the risks had been explained verbally, and a consent form this time was obtained, but pneumothorax wasn't listed as a risk verbally, and nor was it listed on the consent form. So exactly the same issue, really, in terms of this quite major risk not having been mentioned at any point, which is then again making it a lot more tricky, or will make it a lot more tricky to defend if it goes any further. And then can I have the next slide, please? Another example is a patient who was receiving treatment for urinary urgency and anxiety. They were complaining of numbness to the pain, swelling to the sole of the foot and the toes following treatment, and that was allegedly preventing her from wearing shoes and walking. Now, all risks in terms of nerve damage were relayed verbally, and consent was obtained verbally, but again, no written consent form was obtained. And again, there are various issues with that. Now, I'm going to go into the reasons why getting this consent and what you write down is so important. So back in 2015, so I can't believe it's that long ago now. Sorry, it's the next slide, please. There was a very important case called Montgomery against the Lanarkshire Health Board. Now, Montgomery related to a woman of quite small stature who was diabetic, and she gave birth to a baby who was quite a large baby. And in this particular situation, it was very much felt that she shouldn't have been advised that she should have a natural birth. It was felt that she should have been advised to have a cesarean section. And unfortunately, the baby suffered shoulder dystocia, and it meant that as the baby was being born, they couldn't get enough oxygen to the baby, and so the baby ended up being born with various long-term severe sort of like, damaging consequences, and it ended up being a very high payout. So in this particular case, the problem is that the doctor didn't warn about the possibilities of shoulder dystocia and the associated consequences from that. So that's obviously a massive risk which wasn't detailed. And frankly, there's a lot of debate within sort of medico-legal circles around why this case has ended up being, the lead case on this, because it should never have got to that point. An issue that big should always have been talked about. And so we've ended up with a case which is based on a matter like this, where really such a big issue as shoulder dystocia and the possible sort of, really dramatic consequences from that should always have been mentioned to a patient. A better example would probably have been a case where it's a far less likely scenario would occur. But anyway, we've been sort of lumbered with this case, and what was decided was that what you needed to consider in each situation was, would a reasonable person in the patient's position be likely to attach significance to the risk, or ought the doctor to be aware that the particular patient would be likely to attach significance to it? So that was a key part of the judgment which came out. So if you just sort of pause and think about that, and I'll set it out again. So you think of, not in this situation, a woman giving birth, but you with your patient sitting in front of you. So would this patient sitting in front of you, so any other person similar to your patient, with your patient's particular character and your patient's particular desires and lifestyle and everything else, would they be likely to attach significance to the risk? Or ought the doctor, or in your case, the practitioner, be aware that that particular patient would be likely to attach significance to it? And I'll go in more detail into what that means, but essentially it's all about trying to get into the patient's head. Now, the way you have to do that is obviously to build up a rapport with them and elicit what's important to them and what isn't. So if we go back to our pneumothorax examples, there, would a reasonable person in the patient's position be likely to attach significance to that risk? Well, I would say absolutely, and I would say the pneumothorax is very similar in terms of the potential gravity to something like shoulder dystocia and the possibility of the oxygen supply being cut off, and then a baby being born with cerebral palsy or similar issues. So it's just a sort of, to really get that in the front of your mind, that when you've got a patient in front of you, talking to them about what can go wrong. I know you don't want to scare them, but it is really important that they are aware of what can go wrong, because then they are empowered. Don't really like using that word, but it does then empower them to make the decision as to whether they want to carry on and undergo a procedure where they are taking on that risk, however big or small it is. So if I have the next slide, please. The judgment went on to say, and this is what I was talking about, it's consider the nature of the risk, the effect the occurrence of the risk would have on the patient, the importance to the patient of the benefits of the treatment, the alternatives to the treatment, and the risks involved in those alternatives. The assessment is fact sensitive and sensitive to the characteristics of the patient. So again, this is really highlighting the importance of the individual, which sort of goes hand in hand, I suppose, with the society we're in at the moment now, where the rise of the individual is all around us, for good or bad. And really consider the nature of that risk and the effect that risk would have on the patient, and how important it is to the patient that they undergo this treatment, taking into account that risk. And also, are there different alternatives that you can carry out which are less risky? And then you also need to talk about the risks involved in those alternatives. Now, I can imagine at this point you're sort of sighing, saying, well, this is ridiculous. The risks in acupuncture are so small that I could be here all day talking about it. And I mean, we can have a bit of a discussion afterwards, but I think it's just sort of trying to get into your mind that in every scenario where you're talking about a course of treatment, it's really important to make sure that you don't hide the reality of the risks. And if they are small risks, one way you can deal with that is talking about the percentage chance of something going wrong or not. So, what does this mean in practice? If I can have the next slide, please. What it means is, it's not about whether a patient signed a form or not, but if they were provided with all the information that they needed to reach a considered decision. Now, I would add to that in terms of the examples I've discussed with you previously, where there was no form at all. And, clearly there needs to be a form. I'm actually doing some work with Hannah and Helen, looking at the sort of the consent form at the moment. So it's not about whether they signed a form, but we do need to make sure, as a bottom line, that you do have signed consent forms in there. But then what it's about is, what are they actually signing to say they've understood, and where is your evidence of the conversations that you have had about risk? So a dialogue with the patient is key. I just thought I'd sort of try and open it up to the floor a little bit. If anyone wants to sort of shout out, what do you think is meant by dialogue with a patient? How might you characterize that? It's fine if no one wants to answer, that's fine. I will carry on. So if we have the next slide, please. So from a legal perspective, what dialogue means is that each patient should be taken in isolation, and the clinician should make no assumptions as to the information that a client might want to know or what the patient might consider is significant. The clinician should be aware of how their own preferences might influence the advice they give and the language they use. So again, that's just really thinking about how you might have a particular approach. And how I tend to explain this is we've moved away from a more paternalistic approach to one where, again, you're sort of putting the decision making in the hands of the patient. Now, different people have got different views on that. I've spoken about it at length previously, and I've said, frankly, if I'm going to see a doctor or an acupuncturist, and I've seen acupuncturists before, I would actually, yes, I'd quite like to know what could go wrong, but at the end of the day, I'd far prefer them as the expert to tell me what they think is best for me, because that's why I'm going to see somebody. Just like if someone comes to see me for legal advice, once I've understood what their situation is, I will ask questions. I will say, well, what's more important to you? Is it more important that you end up on good commercial terms with the hospital you're working for, or is it more important that you clear your name, for want of an example? And once you've sort of taken that into account, my client wants me to come down on one side of the fence or the other. People tend to get fed up with lawyers that are wishy-washy. And in a similar way, my preference certainly is that when I go to see a doctor, you can forget a lot of information, and so it's much easier actually if they talk to you and then they tell you what they think is best for you. But anyway, that doesn't matter. It doesn't matter what I think, doesn't matter what I might want. The way it works now is very much that it's not to do with what the clinician's own preferences are, and you definitely mustn't let those preferences influence the advice that you're giving and also the language you use. So you've got to try and be balanced in how you're talking about the options. So you've got to be as objective as possible, and you need to make sure that you're engaging with the patients actively, getting them to talk to you about them and what's important to them, and then get them to ask lots of questions. And at the same time, you try and explore their needs and their values and their priorities in order to come up with a solution which is reached together. So that is the meaning of dialogue, according to Montgomery and cases since Montgomery. So to sort of help you with that, what sort of things do you need to ascertain? If I can have the next slide, please. So what you need to do is you need to dig into things with the patient, such as why are they coming to see you? What are they presenting with? What are their aims from the treatments? Are there sort of certain trigger events in terms of their behaviour or the issues that they're coming to talk to you about? What are their main concerns and worries? I mean, I'm sure the thing is, I'm sure you do this, and you probably do it, to be honest, more naturally than some of the consultants that we work with. Certainly the acupuncturist that I saw was wonderfully empathetic and kind, and we had a very long, I think, the first consultation and treatment was about an hour and a half, and I think the first consultation was about half an hour, and I felt that she really did try and get to know me, holistically. So I think you do all this, and you probably do document it all, but it's just to sort of to sort of hammer this home, really, just because unfortunately some of the cases we see, this isn't evidenced. I'm not saying it wasn't done, I'm sure again it was, but it's just, it needs to be evidenced. So just try and sort of get the patient comfortable and talking to you, but try and get all of this information out in terms of, so what the main aims are, in terms of what improvements they're looking for, what the functional issues are that you are going to look at trying to treat. Really key, any previous relevant medical history. That's really fundamental, not least because if this patient potentially should be going elsewhere for treatment, then that needs to be ascertained and communicated as soon as possible, and you don't want to get sort of sucked into doing something that actually you shouldn't be, or where they might be better off seeing someone else. Or certainly talk about the alternatives and document that you've spoken about them seeing somebody else, and elicit their expectations as well. And then if we can have the next slide, please. it's also about trying to find out what their views are, how realistic are they? This is a really big one. Sometimes patients can be hugely unrealistic about what can be achieved. And sometimes I think they can seeing an acupuncturist as a panacea for issues in their life. Perhaps they're not happy with all sorts of personal issues, and they think that this is going to be, their salvation, and that's highly unlikely. So again, sort of really try and ascertain how sensible they're being in their outcomes, and try and communicate that there can be no guarantees as to the outcome. Find out what they think about any sort of recovery from the treatment, and certainly what the risks are. And as I've said, really document all the options that are discussed. I would set out the recommendations as an agreed plan, and where you can, I double check their understanding. Now, with some of our consultants, so with spinal surgeons, for example, I've mentioned previously, some of them actually will test patients. So before they operate on them, they'll make them do a test online, and until they get 100%, they won't operate on them. I am not suggesting that you do that. That would clearly be bonkers to be doing that in your line of work. But if you can try and encourage them tell back, if you can just try and check their understanding in a subtle way and within the time frames, then that's something that I would definitely recommend. If I can have the next slide, please. So in terms of how you should sort of be trying to protect yourself and the patient, I would detail any sort of exam that you've performed, say perhaps where you've checked the tongue, that sort of thing. I would detail that. I'd detail which treatment possibilities you've examined and explained. So perhaps you've talked about adding something like cupping into the treatment, or you might have discussed moxa, the use of moxa. We obviously spoke about that last time. So where you're looking at different aspects and also the different pressure points, it's just really useful for you to talk about those and where there are pros and cons, to set those out. Perhaps where someone's particularly sensitive to pain in some areas of their body or whatever, you might talk about how ordinarily you might treat that point, but because of something they've told you, you won't. So that's where you would talk about that, but really crucially write it down. You include the possibility of doing nothing. Again, I know that sounds balmy, but when you see how some of the claims are phrased, essentially one of the big arguments around consent, it relates to causation in a civil claim. So breach of duty is relatively straightforward. You have to establish that a practitioner owes a duty to their patient. So there's no doubt that you as practitioners, you owe a duty to your patient. So the next step is to find out whether during the course of treatment you breached your duty of care to that patient. So let's say that you were needling the patient, and then unfortunately the patient suffers an pneumothorax or they suffer some sort of nerve injury. The next point is, did that particular issue cause the loss that was complained of? Now, this is where it all gets quite interesting, because if you have not warned the patient that that particular action could have that specific outcome, what the patient can say, it's a slam dunk argument for them, is, well, had I known that I could have had pneumothorax or that I could have ended up with a nerve injury, I just would have said I don't want the treatment at all. I'll just pack my bag and go home, and I don't want to have acupuncture. Now, you and I know that very few people who make it to your room and end up undergoing treatment would ever turn their back on that. You know that they're coming to you because they've, they're in pain, or they are, desperate for a baby, or they have got to their wits' end with other practitioners, or whatever it is. They're driven to come to see you, and they'll try anything, and they're highly unlikely to turn down the treatment. That is the human nature. We want to get better, and most of us will accept a level of risk. But the problem is, if there's absolutely no proof that you've warned them that there could be this particular outcome, it's a slam dunk argument for them to say, you didn't warn me of that. I would never have had the treatment had you warned me of that. So that's why including the possibility of doing nothing is actually really helpful, because if you've written down, I did say, well, you could just do nothing about it, they say, no, I want to proceed, that's actually a really helpful element for a defence. Now, I don't want to sound as though I'm encouraging defensive practice, but it's just quite a useful tip, and it also just focuses your mind on why it's so important to be talking about what these risks are. Because, as I say, if there's no evidence that you've spoken about that particular risk, it's very easy for the patient to turn around and say, well, I just wouldn't have had the treatment. Now, there's different things we do. You then, if it gets to this point, which it rarely does with acupuncture cases, but if it got to the point of court proceedings, we would be putting the patient to proof, and we'd be saying, well, clearly they were highly motivated to have this treatment because of X, Y, and Z in their history and their medical records. And we can see all of these Google searches they've done showing that they've researched the risks associated with acupuncture. But, you know, the cases in this sort of scenario and arena don't tend to go that far. And therefore we can't rely on the luxury of putting the patient to proof that they would have never had that treatment. And so again, that's where it can be tricky if you've not just set out the risk clearly in the notes and in the conversation. And also it can be helpful to separate out general limitations from personal limitations. So again, what's a general risk, so a pneumothorax or some sort of nerve injury, but what's specific to this patient? So if this patient has got diabetes or skin allergies or something that's very specific to a certain that could be a contraindication to a treatment, then you need to establish that and be making it very clear that because of their particular situation, the risks of something working or not working could be higher or lower. So it's just, again, it's just personalising the information that you're giving. If I can have the next slide, please. It's really useful to see consent as a journey. So, you know, a signed consent form, which, as I say, we really need to be seeing more of these signed consent forms than we are, but the signed consent form is just one tiny part of it. It's a process which begins as soon as you know, the patient sort of comes into the reception area, and it only ends with your final discussion in terms of your final treatment, really, because things will change each time you see them. You'll be perhaps trying a different treatment each time. So, you know, at each opportunity, it's really useful to be taking the whole sort of discussion with the patient and seeing it as a journey. And one thing you can consider doing is recording consultations. I mean, again, that's opening a little bit of a can of worms. We do suggest it with our consultants and our dentists. If you record it, you'd obviously need to tell the patient, and you might want to say to them, you know, you can record this on your phone as well. It's just something to think about. It's perhaps a bit too you know, corporate, or, as I say, defensive within your area. And I think it's better for now probably to just be focusing on the notes, but it's that balance between making sure that your note keeping is good enough. And then the next slide, please. So a tick list, which is sometimes viewed as being enough for consent, certainly isn't. And another area, you know, we spoke about moxa before, and we talked about the different types of moxa cones and how different, there can be different instructions and different risks associated with different products. And one thing that you can think about doing, and again, this may apply more to where, for example, we've got an orthopedic surgeon who's using a particular hip implant or whatever, but, you know, it can be really useful to, if there is some patient literature that you're giving out, ensure it's provided and actually get them to sign and confirm they've read and understood it. That's really helpful. That can add to this whole consenting journey. And also, if there are disclaimers relating to products such as moxa, I mean, moxa is really the only one I can think of, or I suppose the needles. I mean, it didn't happen when I had acupuncture, but again, it can be something to discuss as to whether, you know, you want to sort of include any of those disclaimers relating to those products within your consent pack. I mean, that would be, you know, the sort of uber gold standard of consenting to do so. And again, it might be overkill, but I think it's something for me to discuss, certainly with Hannah, and also some of you may wish to pick up on that, shortly. And I just wanted to give you a word on record keeping as well. If I can have the next slide, please. So this is inextricably linked with consent, in my opinion. If I can have the next slide, please. And it's quite helpful to think about some of the key questions that we talk about when we're thinking about I don't know, a detective story, when we want to know who, what, why, when and where. Think about, in your notes, always think about your audience, who is going to read them. You'll probably sit there thinking, well, I'm going to be reading them, no one else is going to be reading them. But actually, there might be another practitioner who might read them. There may be, unfortunately, it might reach this point where a patient might ask to see the notes. So always just think carefully about the fact that it won't necessarily always just be you that's reading those notes. What are you recording in your notes? What did you definitively or definitely say and discuss, and how can you prove it? When did you see the patient? Make contemporaneous notes. So write up as you go along. Leaving it for later can be fatal. I mean, it sounds a bit melodramatic of me, but memory is a funny thing. And I know I've been in personal situations where I've had a phone call and then sort of 20 minutes later you're recounting the phone call to someone else, and there are key elements that you can't quite remember, whether that's because you're in a heightened state of emotion, whether it's because you were distracted at the time, whatever. It's really important that you write as you go, because otherwise you could leave out crucial bits of information. And also, again, speaking from my experience, that's one reason I'll take a trainee solicitor or a colleague with me to a meeting, because when I'm doing the talking, I am not going to remember everything I said. You can be pretty damn sure I would have said what I wanted to say. And, again, this is where we all fall foul as professionals of this. Actually, it's highly likely that in the cases that we've said there was no verbal consent in respect to pneumothorax, for example, there probably was, but because there's no recording, and because either electronically or siren, because there's no electronic or written documentation, we can't prove it. And it's incredibly frustrating for you, for me, for any professional, where this is your day in, day out, this is your job, and you probably are telling all these patients exactly what you should be, but if the evidence isn't there, then you can't prove it, and it's very, very frustrating. So as I say, write up as you go along. Looking a little bit at the storage of notes as well, and also just documenting why you decided on a particular course of action as against other possibilities. That is less relevant in your day-to-day consultations, I think. It's more where you've got a bit more of a decision to make as to one treatment over another, for example. If I can have the next slide, please. So in terms of who, avoid rudeness. I've seen some terrible examples in the past of people, referring to patients as fat and not using a word such as overweight, or you can. I've seen some really short, or doctors who've described patients as being mad, or those sorts of words, which is just really, really difficult to deal with further down the line. So just obviously always bear in mind that someone else could see these notes. They aren't for your eyes only. Make sure you take a detailed medical history, record it in detail, highlight points that any other professional might need to be aware of, such as a GP in the future. And just think as well about, can your colleagues actually understand what you're saying? If I can have the next slide, please. Again, on this theme, handwriting can be a massive issue. I don't know, I'd be interested to know afterwards how many of you tend to record the notes electronically now, and how many of you write. I know, again, when I consulted an acupuncturist, I know that she was writing. I mean, that was a good 5 years ago or so now, but she certainly was writing her notes. I didn't examine them. I don't know how good the writing was, but this point came to some infamy a number of years ago, where an elderly woman died in Frimley Park Hospital after a nurse administered 25 milligrams of morphine instead of 2.5 milligrams. And that happens. The number of times we see errors like that. I've been dealing with, for one of the large online pharmacy providers, who's one of our clients, only the other day, where the wrong drug was prescribed for 2 years by numerous different individuals, and in individual GPs, because there's been an error, one or two letters wrong in terms of the drug that's been prescribed, and it's been misinterpreted, and in fact even the patient had gone on and ordered the wrong drug. And then I've got lots of other examples of where too much or too little morphine or other controlled drugs have been prescribed. So, it's really common, and that is particularly related to handwriting and lack of accuracy. So it's just, a big reminder about accuracy. If I can have the next slide, please. So then, the question of why. So without hard written proof, a different conclusion will be drawn, which I think I've sort of emphasised enough, really. So poor record keeping can endanger the patient and make it harder for your colleagues, potentially in terms of if there's an issue that a red flag, for example, that you haven't sort of passed on. I've put here, explain your working. It's a bit like sort of thinking back to when you were doing maths at school and you had to show how you reach your answer. It's a really good way of thinking about what you've told the patient, why you've reached that particular outcome. And if actually you end up having to do something different, then again, if you can just explain that and document it, then that can help as well, because it might be that the patient finds that it's too painful in one particular, particularly sensitive area that you said that you would needle, for example. So if you decide to change, then it's just important to highlight that. And I've just put here, again, one of our roles, we're almost acting as detectives. So make it easy for us in the event that unfortunately you do end up facing a complaint which needs to be defended. And I would add to that, it's not just about when we're involved, it's sort of right from the start. If you get a complaint, it's so much easier if you can just bat it back with our assistance at the complaint stage, because you've got some brilliant notes there which show that the claimant is wrong and that you did actually talk them through all of the issues appropriately. So on the sort of what side of things, which is the next slide, please. Again, the reason this is important is because if it goes as far as court, which again is highly unlikely, but even rowing back from that, the pre-action phase of things is more common. We need evidence, everyone needs evidence, and what you want to avoid is being in a situation which has occurred in those 3 cases that I've set out as examples earlier, where you're essentially in a he said, she said scenario, and at that point it's really difficult to win, actually, because the argument is, although, as I said, as professionals, I'm sure you probably said what you argue you did, just as I will have said it in the course of my meeting, because we know our stuff and we're the experts. It's not being arrogant, it's just a fact. We're the experts compared with the people sort of sitting in front of us, unless you happen to be giving acupuncture to some, world-leading acupuncturist, or I happen to be giving med mal advice to some med mal lawyer, which I can't see that scenario. But anyway, the point is, you probably have said exactly what you should have done, but the way the court sees things, it's a very, very patient-friendly environment in the courts. It's a known fact. It just is. The courts favour the patients. And the court's view tends to be that whereas you see someone, you'll have, 10, 15 appointments a day, your recollection of an individual patient will not be as good as the recollection that individual patient has of you, because they come to see you and probably no other acupuncturist, and it may be their first or second appointment or whatever. The point is, the view is that their memory is better than yours. We can't do anything about that. All we can do about that is to fight against it by documenting everything, as I've discussed, to show that it went our way and not the way that they're saying. So, you know, make sure that you've set out what was important to the patient, what you assessed, your reasons for the decision, and any relevant observations. And also, in terms of the when, I've said this already, so it's reiterating it really, in terms of just recording your findings and consultations at the time or as soon as possible afterwards. Sorry, this was the next slide, please. And also just show at the time that you gave a copy of a certain leaflet, or you referred the patient to a certain website. So this is going back to that point about including extra documentation. And if you keep that record then and there, as policies can change, and obtaining old ones can be a headache. So if products are changing and so on, so it's just quite useful to do that as well. And then in terms of record keeping as well, if we have the next slide, in terms of the where, many insurance policies actually require you to keep records for a minimum of 10 years and in a secure place backed up. So we recommend you store them at the clinic or else on an encrypted laptop. And if I can have the next slide, please. The takeaway points really are to keep good, clear points of all your patient interactions: the who, the what, the when, the where, and the why. To consent the individual, you really need to look at it from their perspective and really think about what other professionals might have told you about the patient. I've put this in because it's really important. Consult with us before you get into responses to complaints to patients, and I'll highlight that point because we do have some examples of where I think, because your relationship tends to be very close with these patients, and they can sometimes view you as more of a friend than a professional, and you want to maintain that relationship, which is totally understandable and admirable. The issue is you'll sometimes get into discussions with them and perhaps admit things that you don't need to, or you will agree that the outcome that the patient's complaining about is linked to your treatment, when actually it could very well not be. And so I would really beg you, to say that we are here to help you, and you can come to us for any support in that regard. And finally, the final takeaway point really is, litigation is lengthy, it's expensive, it's stressful, it's costly. And however good your lawyers are, it's a lottery in terms of which judge you end up in front of, and all the other points I mentioned at the beginning about what can make it a lottery. So if you adhere to these tips, hopefully you will remain safe and you won't end up caught up in litigation. So they were the main points I had from a legal perspective. I'm obviously very happy to take any questions if you have any, or you may wish to run off to enjoy the last of the summer's evening. I can see there's a number of things coming in about the 7 years. That's fine. I mean, insurance policies tend to require 10 years. I can certainly double check what the specific policy says for you. But if your guidance is 7, then the insurers would be okay with that.
Thanks.
Do you have any numbers of risk of pneumothorax? Is that the end of the? So in terms of the, so that's a question for the council. I certainly think it would be a really good idea to know what the risk is, because phrasing it as a percentage can actually be really helpful when you're speaking to a patient. Again, it's always about how you phrase it, because you don't want to scare them off. But if we know that either now or we can follow it up, that would be useful, and it'd be good for me to know that as well, actually. And I think another one flashed up about a consent template. So I'm actually working on that with Hannah at the moment. I'm sorry, it was terrifying. It's I mean, the problem is it's one of these things where so hang on. So obviously, so sorry, I'll just finish my comment around the terrifying bit. I mean, I'm obviously talking about it from the worst perspective, and I think the likelihood of anyone ending up in front of court or even in the pre-action stage is incredibly low. It's just to highlight the fact that we're here to support you, and it's just about you know, we see the worst of things, really. We don't see all the really happy patients and all the wonderful sides of things. So we are learning and sort of preaching from that side of things. And all we want to do is, after, you know, sort of 14 years of doing this, it's incredibly upsetting when you have to defend individuals who will have definitely consented, but it hasn't been written down. So that's the main message from there. The question about the 5 elements. You see a lot of clients with mental health. How is it best to determine competence? So do you mean in terms of their competence to actually be able to consent? I mean, that's really a whole topic in itself. What I would say is that it depends on the level of their mental health issues, really. I don't think that having mental health issues will definitely not. An individual having mental health issues such as depression and anxiety does not make them any less able to consent to a treatment. It's more a question of checking whether they have capacity. And I'd be surprised if many of the patients coming to you, you know, actually lacked the capacity to make a decision. I mean, that would be situations where, for example, they had really severe dementia, or they had a very, very sort of low age of maturity. For example, it would be those sorts of situations. I mean, I can do something separate on capacity, so that's a slightly different question. But, you know, I think where they've got general mental health issues, I think what you just need to remember is to really highlight to them that you doing some acupuncture is not going to resolve all of those issues. They've got to sort of embark on a sort of holistic program, which could also include speaking to their GP and being prescribed drugs, for example. Were there any other questions?
It doesn't look like there's any more coming through. I will just stop the recording.